We have three cameras up. Is that one is in the medical?
Yes, Your Honor.
So if you need me to do something out of order, just let me know. I'll do whatever you need.
Okay. Muhammad, who you got up there with you, Muhammad?
Mr. Bella here and Johnson.
Okay, so Your Honor, if you could do them two first, then we can just start. After that, we start with the females and the males.
Okay, we'll do that. So I'm going to read the script and then we'll start with the two. It was Johnson and who?
Berryhill. Berryhill.
I'm sorry, would you say the other name after Johnson again?
Berryhill.
Hill.
It's going to be the fourth one. Berryhill.
Michael Berryhill, Your Honor.
Oh, Berryhill. Thank you. Thank you. All right, so we'll do those two first after we read the after I read the script. So good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm not here to conduct a trial of your case or to take a plea in your case. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you if your case goes to trial. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: the right to the presumption of innocence, the right to indictment by a grand jury for most felonies or by accusation for misdemeanors, the right to a speedy and public trial by jury, the right to see, hear, and question witnesses who are called to testify against you, the right to compel the attendance of witnesses to testify on your behalf, the right to testify on your own behalf or offer evidence in your own defense, the right to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release. And these bonds may be by cash, commercial, or property. If you post a cash bond, someone will deliver the full amount of the bond and fees in cash to the sheriff's office. The sheriff's office will hold the cash and return it to you at the end of your case. If you use a commercial bonding company, someone will have to pay a fee to the company for their service. The fee will not be returned. I don't know what the fee will be, but it is normally a percentage of the bond. Finally, if you use property to post a bond, the property will need to have a net equity at least 3 times the total amount of the bond. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. This special condition will be provided to you on a separate form. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you could remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Finally, I need everyone to raise their right hand. Do you swear or affirm that any testimony that you give during this proceeding will be the truth, the whole truth, so help you God?
Yes, sir, I do.
Okay, I'm ready to start with Mr. Johnson and Barry.
Yes, Your Honor. Which one would you like to start with?
Whichever one is ready to go.
This one, Barry.
Sir, are you Mr. Berryhill?
Sir.
Mr. Berryhill, you've been charged with 1 count of family violence battery. There's going to be a $5,000 bond set on that case, and there's going to be a stay away provision to stay away from Tony Berryhill. Do you believe you can post this bond, sir?
No, sir. Can I ask for a reduction in the bond because of a physical condition I have?
Okay, and what's the physical condition?
Right, it's trying, but it's still like I have my balls, genitals have been cut off, and I have no skin whatsoever on my butt, penis, my thighs. I have an ostomy bag. And I just trying to get out to get to a great hospital where I can, get the treatment for this.
How long have you had this condition, Mr. Berryhill?
I've had the condition for 4 or 5 years, but I just had the surgery on the condition two months ago. But it still hasn't healed because the portion of the skin, all the skin they had to cut off, I have to wait till it grow back a little bit to get a skin graft, and they don't know when that will be.
Okay, I'm sensitive to that condition. The warrant says that you struck somebody with some object. Mr. Tony Berryhill. You struck
Yes.
Tony Berryhill with an object.
Me and Tony got to find him with the remote. He actually was the one that got charged with this back in 2016. Some kind of way they locked him up and dismissed the case. So I don't know how did I get the warrant for the same charge.
The warrant was issued actually November 3rd of 2016 for you on this charge. So, Mr. Berryhill, this is what I do. I will reduce your bond to $2,500, and you're still going to have the stay away provision on your bond to stay away from Mr. Tony Berryhill. Do you have what? Let me tell you this: you're going to have a preliminary hearing date that's going to be set for April 20th at 8:30 in the morning, but that date is going to get waived upon your bonding out. Do you plan to hire your own lawyer, or do you want me to see if you qualify for the appointment of a lawyer?
Appointed lawyer.
Okay, you do qualify, Mr. Berryhill. I'm going to appoint a lawyer to represent you. Do you have any other questions of me, sir?
No, sir.
Okay, you're free to go back, Mr. Berryhill.
Mr. Johnson, can you step up for me, please?
And you are Mr. Johnson.
Yes, sir.
Give me 1 second, Mr. Johnson. Let me get your paperwork. Okay, Mr. Johnson, you understand what you've been charged with, is that correct?
Yes, sir.
Okay. So bond is going to be denied at this point on this charge. You're going to have a preliminary hearing date set for April 19th at 8:30 in the morning. I'm going to also set a bond hearing date for April 23rd. On this charge, would you like for me to see if you qualify for the appointment of a lawyer, or do you plan on representing yourself or hire your own lawyer?
Hired a lawyer. You know, I was out of town, I drive trucks, and just didn't do enough investigation. I felt like that was calibrated, you know what I mean, calibration of evidence, not really, you know, research. And before this situation, I came back from out of town. I've been driving close to 20 years, and I hired a lawyer and everything, and it's a whole bunch of calibrated, you know, allegations with the group, you know what I mean, before the judge, well, my lawyer even got a chance to investigate anything, and this is a serious matter, you know, and
Yes, it is a serious matter. And then I heard you say that you've already hired your own lawyer.
yes,
What's your lawyer's name?
his name is, I got it on a piece of paper. I didn't get a chance to bring it up with me, but his name is John Lombard.
Okay.
Yes, I paid him, you know, he came with me yesterday to meet with the detective, you know, with the quiet date. I said I was coming back from Dallas, and she came back from Dallas.
Okay. Okay. Well, do you have any other questions for me, Mr. Johnson?
There's nowhere, of course, I figured I probably wouldn't get a bond, you know, right off with these type of, you know, allegations and charges.
Right. For this type of charge, it's going to have to be some deeper level of investigation that's done. But you've hired a lawyer. That's the right thing to do. Your lawyer's the person that's there to advocate on your behalf. Okay. Any other questions, Mr. Johnson?
Yes, that's it for information I would need. I gotta wait till the 23rd.
Yes, sir. Make sure you inform your lawyer of these court dates. Your lawyer will most likely be able to speak with the district attorney's office before these dates come up, and they'll be able to kind of understand sort of where they stand, where everybody stands as it relates to the allegations and the investigation. So that's going to be the best thing for you. Okay. All right. You're free to go back, Mr. Johnson.
Thank you, Your Honor.
You're welcome. I see we have Miss Fitzgerald. Do we have any Spanish speaking persons here today?
Good morning, Your Honor. According to my list, I saw two. Maybe they bound out, Mr. Juarez and Mr. Lopez.
Let's see.
I mean, the names, maybe they speak English, maybe they bail out.
Lopez has bonded out. Juarez has bonded out.
Okay, there you have it.
So just so we can check just before we don't have Miss Fitzgerald coming back and forth. Would you two gentlemen check on the male and female side if anyone believes they need a Spanish interpreter?
The male doesn't need one, Your Honor.
Okay.
Neither does the female.
Okay.
Okay then. Okay
Thank
then.
you, Ms. Fitzgerald. You have a good day.
You too, Your Honor. Bye-bye.
Goodbye. All right, let's start with the ladies.
Okay, y'all. The first one is going to be Ms. Clark.
Okay.
Clark.
Good morning, Ms. Clark.
Morning.
You're charged with 1 count of criminal trespass, 1 count of public drunkenness. Uh-oh, you disappeared on me. Okay, you're back. I've set the bond on both of these offenses at $1,000 each, so that's a $2,000 total bond. Do you believe you can post that bond, ma'am?
No.
Okay. Now, I would encourage you to contact the bonding companies that are authorized to write bonds here in Clayton County. That is literally the only reason they're in existence, to help people with bonds. So they should be able to help you and work with you. And some of them will even put you on a payment plan. You're going to have a preliminary hearing date that's going to be set for April 20th. That date will be waived upon your bonding out. It doesn't look like you filled out the form for the appointment of a lawyer. So are you planning on hiring your own lawyer or representing yourself?
No, I don't need a lawyer.
I'm sorry?
I don't have one. I don't have one.
Okay, would you like for me to try to determine if you qualify for the appointment of a lawyer?
Yes.
Okay. Do you currently have a job, ma'am?
No.
Okay. So if you want me to appoint you a lawyer, you do qualify. Do you want me to appoint you a lawyer?
Yes.
Okay. So what's going to happen, ma'am, because you didn't fill this form out before, there's going to be information that is here as it relates to your address. I'm not going to ask you that information over this proceeding because this is being published on the internet. So you're going to have to make sure you give the sheriff's department your correct address so that when the lawyers receive this, they'll be able to retrieve your correct address and they will be able to communicate with you. The law firm that is going to represent you is Lister and Holt. First name Lister, second word Holt. That's going to be the law firm. If you don't hear from them in a couple of days, you need to reach out to them and contact them and let them know. They're going to get the paperwork today, and so that you can clear up the information as it relates to the address. But as I stated before, because this is being broadcast over the internet, I'm not going to ask you for your address because I don't know who's going to be watching, and I don't want you to receive any kind of mail or request or things of that sort. Okay? Do you have any questions for me, ma'am?
No.
Okay, Ms. Clark, you're free to go back.
Thank you.
Just sit in the back. Next is going to be Davis.
Okay.
Ms. Clark, get your trash out.
Ms. Davis, you've been charged with 1 count of battery. The bond is going to be set at $5,000, and there's going to be a stay away provision on this bond to stay away from Inga Fox. Do you believe you can post this bond, ma'am?
It's not her last name.
It's not?
No, she lied.
What's her last name?
Tharpe, Tarpe.
Okay. So it's going to be to stay away from Miss Tarp, T-A-R-P.
No, Tharp.
T-H-A-R-P. Thank you. Do you understand this stay away provision, ma'am?
Yeah.
So with that slow response, let me tell you, I don't know, other than what I've read, I don't know what happened in this case, right? So if this is a situation where Miss Tarp is not afraid of you, she can contact the solicitor's office and she can ask for this stay away provision to be lifted, and it will be lifted. Okay. We put the stay away provision because we don't want to, whatever the situation that led to you appearing before me this morning, for that situation to flare back up when you bond out. So that's why it's there. You're going to have a preliminary hearing date that's going to be set for April 20th. That date is going to get waived upon your bonding out. Would you like for me to see if you qualify for the appointment of a lawyer? Okay. Ms. Davis, you do qualify for the appointment of lawyer. I'm going to appoint a lawyer to represent you. Do you have any questions of me, ma'am?
Okay, so since this is my first offense,
I'm sorry, I heard first offense and I didn't hear anything after that.
I'm confused, like,
What are you confused about?
okay, so you said it was $5,000.
Yes, ma'am.
Will we have to like pay that whole thing now or what? Okay.
So you can pay the entire amount in cash to the sheriff's department and they will hold it and they will return the entire amount to you upon your case being resolved. You can go through a bonding company that'll charge you a fee that is generally a percentage of that amount, but they will keep the fee that you pay them. If you have property that has equity at least of $15,000, you can use that property to post your bond. Sheriff's Department put a lien on the property, and then when your case is over, they'll take the lien off.
Okay.
That's any other questions, ma'am?
No.
Okay, you're free to go back.
You can get back to just close the door for us. Next is Miss Deloney.
How you doing?
Good morning. You're Miss Deloney.
Yes, sir.
Okay, so you have been charged with 2 drug-related offenses and 2 driving-related offenses. The bond for the drug-related offenses is going to be set at $5,000 each for a total of $10,000. And for the tag and the open container violation, the bond is going to be set at $500 each. So you're going to have a bond of $11,000. Do you believe you post that bond, ma'am?
What's 12% of that? No.
So I'm a lawyer, so I'm gonna give you my best. I'm gonna give you my best math impersonation. It's gonna be about $1,100. Okay.
I ain't got no choice, really. Yeah.
Okay. And so bonding companies, like I tell everybody, bonding companies, their job is to get people out of jail. So they'll work with you. They'll work with you in a lot of different ways that you may not have imagined. So I would encourage you to call the bonding companies that are authorized by the sheriff of this county to write bonds. Tell them your bond, and I'm almost certain they're going to work with you. Okay. We're going to have a preliminary hearing date because the first 2 drug offenses are felony offenses. You're going to have a preliminary hearing date set for April 19th, but that date will get waived upon your bonding out. Would you like for me to see if you qualify for the appointment of lawyer?
Yes, sir.
Ma'am, you do qualify. So I'm going to appoint a lawyer to represent you. Do you have any other questions of me?
No, sir, I don't.
Okay, ma'am, you're free to go back.
Next is Miss Gibbons. Gibson, my bad, I'm sorry. No, you can go back to the door
Go back to the door. I can make my call in order.
after everybody finishes.
Ms. Gibson, it looks like your case was continued from yesterday to today. You have one charge of terroristic threats, and you're gonna have a bond set at $10,000, and there's going to be a stay away provision on your bond to stay away from Latavion Hillman. Do you believe you can post this bond, ma'am?
Yeah, we'll figure it out.
Okay. Do you understand the stay away provision?
I do, however, that's my husband, so.
So what happens in these types of situations? We don't know you, we don't know your husband. All we know is something happened that led you to be before me today.
Mhm.
And what we don't want, out of an abundance of caution, what we don't want is for whatever to happen to flare back up. This could have been a 1 in a million shot thing, or it could have been something that happens every day. We don't know. So we put the stay away provision so that that does not occur. It actually protects you and it protects him. If he's not afraid of you, this is a felony offense. He can contact the district attorney's office and tell them, I'm not afraid of her. I want that stay away provision to be lifted so that she can come back home. And that's fine. So that's why it's there. And that's why we do it. And I hope you understand that.
I do.
Okay. You're going to have a preliminary hearing date that's going to be set for April 19th at 8:30 in the morning.
Okay.
Do you plan on hiring your own lawyer representing yourself, or do you want me to see if you qualify for the appointment of a lawyer?
I'd like for you to see if I qualify, please.
Okay. Are you currently employed, Ms. Gibson?
I'm not employed, but I am receiving unemployment.
Okay. So the fact that you're not employed, that qualifies you for the appointment of a lawyer. And there are little glitches that happen. So I don't have a form for you, and I'm going to have to get a form, and I'm going to have to produce that.
Your Honor, I had it, they probably just didn't, she was one of the last ones that filled it out, so after this court is over, I'll get it to you. I'll make sure it'll get over to you.
Okay, thank you. So the deputy is going to send that to me. It generally takes me about 2 hours after the hearings are over to do the paperwork, and Sheriff's Department sends me paperwork all the time. So he's going to send it over, and then we'll get that attached to your paperwork, and then we'll work everything out. So do you have any questions of me, Ms. Gibson?
How soon after this can I call my mama and let her know to go to the bond company?
So the Sheriff's Department, they will allow you to use the phone after this hearing, but it's not like a situation where you're like, you know, I've just had my hearing, give me the phone. They have their own procedures that they follow, but they will allow you to use the phone.
Well, I guess my question is how long will it take her to be able to do this process? Like, how long would it be in the system for her to be able to go to the bonding company and they see this information?
So it generally takes me 2 hours after the hearings are over. And I never can gauge how long the hearings last because my job is to answer questions. So some days I have a lot of questions, some days I have no questions. So it should be about maybe 3 o'clock, 4 o'clock today.
Okay, thank you.
But yeah, but just, you know, Sheriff's personnel, they start working when I send them the paperwork over. So it's not on them, it's on me if it's going to be a little bit longer than that, okay?
Okay, thank you.
All right. You're welcome. You're free to go back, man.
It would be Miss Jones next, but she's a fugitive, so we're gonna do her last.
Okay.
Next is gonna be Miss Kimball.
Okay.
Kimball.
Ma'am, you've been charged with one count of financial transaction card fraud.
Yes,
Bond
sir.
is going to be set at $5,000 for that. Do you believe you can post that bond?
I hope so, yes, sir.
Okay. You're going to have a preliminary hearing date that's going to be set for April 19th at 8:30 in the morning. That date is going to get waived upon your bonding out. Do you want me to see if you qualify for the appointment of a lawyer, or have you hired your own lawyer?
You can, see if I qualify.
Okay. Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back.
Thank you.
You're welcome.
Next is gonna be Ms. Polson.
Ms. Colson, you've been charged with criminal trespass, damage to property. You're gonna have a $2,500 bond set, but there's gonna be a stay away provision on your bond to stay away from Richard Mitchell. Do you believe you can post this bond, ma'am?
Yes, sir, I do. My father, he came up here today to drop the charge,
Okay.
and he's the one that would actually post my bond.
Okay. So, and so your father is Mr. Mitchell.
Yes, sir.
Okay. What he's going to have to do is he's going to have to contact the district attorney's office, because they're the ones that are going to take over the charge, essentially on his behalf for the state of Georgia. Do you have your own lawyer, or do you want me to see if you qualify for the appointment of a lawyer?
I don't have my own lawyer, but I'm sorry, I have vertigo right now. I'm really busy. So you said my bond is how much?
It's $2,500.
So I have to get a bond to pay. It'll be $200 and something.
Yes, ma'am. Do you want me to see if you qualify for the appointment of a lawyer?
You can. Yes.
Give me 1 second. I'm sorry. I'm going through the paperwork. Okay, ma'am, how much did you make per hour?
I make almost 400 a week.
Okay. Okay, you do qualify for the appointment of a lawyer. I'm going to appoint a lawyer to represent you. And the reason I asked the question that way is because if your father is unsuccessful in speaking to the district attorney's office, you're being appointed a lawyer. The lawyer can speak to your father can sign an affidavit, and that will work towards getting the result that you want.
Okay. But
Okay.
he can sign my bond, right? That's, I mean, he's the only one that I know that actually has the means that I can trust. You know what I mean?
I do. And so generally when the person is named as the victim in the case, they're not allowed to post the bond. So either he will be allowed to post the bond, but if he's denied that by the sheriff's department, he can contact the bonding company and make the arrangements with the bonding company so that the bonding company posts your bond.
Okay, all right.
Okay.
But I have the card, I have my money up here, so I will figure it out. Okay.
Yeah, and that's something that you just speak with the people in the sheriff's department there. They will be very helpful in helping you kind of navigate through those waters. Okay.
All right.
All right. You're free to go back now.
Thank you so much, sir.
You're welcome.
Next is Ms. Pittman.
Okay.
Morning, Your Honor.
Good morning, Ms. Pittman. You've been charged with 3 offenses that are basically related to the Gang Act. There's going to be a bond set for each of these. It's going to be $10,000 a piece, so you're going to have a $30,000 bond. You believe you can post that bond, ma'am?
I know I can't hold that bond.
Okay.
Oh, my Lord.
What I would encourage you to do, ma'am, is to really contact the bonding companies because they will work with you.
Is it possible to ask for a reduction? I'm here for, Your Honor, I'm here for something that I've never been in trouble before. This is something that has to do with my son who is here. And the officer came and talked to me last night and he told me that because they got all of the boys and none of the boys are cooperating, then they said that they were gonna go after the parents. I have a doctor's appointment. I suffer from hypertension. I have a doctor's appointment on Friday. I have a 16-year-old son at home right now. I never even been in trouble before on my own, Your Honor.
These are some very serious charges.
I understand that. I don't even understand the charges, though, to be honest. I know they're serious because that's what they told me they're filling the charges, but I don't even understand the charges because I don't have a criminal record. I haven't been in trouble.
And that's, the way that the gang statutes are written, it really is kind of broad and it brings in a lot of behavior that some people would normally believe that they're not going to be subject to being charged. But the way that these statutes are written, it really is a broad kind of sweep. And so to the extent that this involves your child or anyone else, is something that you're going to have to be aware of moving forward. That to the extent that you are seen as giving any kind of cover.
He's here in Clayton County.
I understand.
He's been here since Thanksgiving. I'm not coming to bond him out or anything. I don't have. He's 17 years old. He do what he want. He think he do what he want to do. When he turns 17 years old, I put him out of my house because he want to be bond. He want to do what he want to do. I can't. Now I'm sitting here on the count of something that he done.
Yes, well, let me tell you some information, then I'm going to ask you some questions, okay, Ms. Pittman?
Yes.
You're going to have a preliminary hearing date that's going to be set for April 19th at 8:30 in the morning, and that's going to be over Zoom hearing like we have here today. Again, I would encourage you to reach out to the bonding companies because they put people on payment plans. They do a lot of things because this is literally their business model to get people out of jail. So you don't have to sit here. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you. I would encourage you to speak to that lawyer, excuse me, about the circumstances of your case and what's going on with you, because a lawyer will be able to advocate on your behalf. And so this is something where this is a warrant that was sworn out by a detective. So this is something where they have been looking at this. Whatever it is, I only know what I read in the paperwork that I have before me. But this is not a situation where a police officer just encountered someone on the side of a road. So you're going to have to understand that and take it seriously, that this is something that if they're coming after you or other people and bringing these charges, that it's a considered decision, not something that they just,
I don't
Yeah.
mean to cut you off, but detective came in last night when they brought me in, and he got my phone. I told him, you could have called, if you would have called me and asked me to bring the phone, I would have brought you the phone. But he told me that he was gonna set up for me to talk to my son this morning, and if I can talk to my son and get my son to cooperate with him, then it would be, he can make this go away from me. I don't even know what's going on, to be honest with you.
Well, ma'am, and that's the point of me telling you about the fact that this came in through a detective coming to a judge to get a warrant is whatever's going on. This is not something where they are just flying by the seat of their pants.
Right.
So you need to really take that into consideration, that this isn't like somebody's is just having a fly by night kind of deal.
What he said to me was that they have all of the boys that are involved. It's supposed to be a clique and they're supposed to be a gang. What he told me, I said, a gang? I'm 38 years old. I'm not involved in a gang. I don't even agree with that. He said, but your son is. He said, we have all of them. And he said, none of them are talking. And if they don't talk, then we told them we were going after the parents.
They've told you what they're doing. And so that's the thing that, people sometimes don't understand how innocently you can get wrapped up in criminal charges by proximity. And so that appears as to be what's going on. And so the police officers have made that determination, and that's what they're doing. And so the lawyer is the person that is there to fight about it and deal with it. But like I said, if they've made this determination, you should not take it lightly.
I'm not. I just want, there's no way that the bond can be brought down some to where I can afford to make a bond.
At this point, no, ma'am. I have to look at the charges. I have to look at what they're alleging, and I have to take everything as true. Everything that you're telling me is true. Everything that they're saying is true. And I have to try to make the appropriate decision as it relates to bond. And so if what they're saying is true, this is where the bond amount comes into play. Okay?
Yes, sir.
Okay. You're free to go back, ma'am.
Can you give me that court date again? It's $30,000 in the contact the bond company.
Yes, April 19th, I'm sorry, is the preliminary hearing date, but that date will be waived upon your bonding out.
Okay.
I have appointed you a lawyer. You should contact the bonding companies. You will be allowed to do that when you leave this proceeding.
All right.
Okay?
Thank you so much.
You're welcome.
Next is Miss Rose Rosaro. I can't say it.
Welcome to my world. Ma'am, you've been charged with one count of disorderly conduct. The bond is going to be set at $1,500 for that. Do you believe you can post that bond?
Yes.
Okay. You're going to have a preliminary hearing date that's going to be set for April 20th, but that date is going to get waived upon your bonding out, and you'll receive a new date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back.
Thank you.
Next is Miss Cetro. Oh, I said it right the first time. No, you go. That's everybody's name.
Okay, Miss Satchel, you've been charged with 1 count of theft by deception and 1 count of criminal attempt to commit theft. Bond is going to be set for both of these offenses at $2,000. So that's a total bond of $4,000. Do you believe you can post that bond, ma'am?
I don't believe you can put a remedy can be made.
Okay. I would, like I've told everyone else, I would encourage you to speak to the bonding companies that are authorized to write bonds in this county. They will work with you. You're going to have a preliminary hearing date that's going to be set for April 20th at 8:30 in the morning. That date is going to be waived upon your bonding out. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. Ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
I do not.
Okay, you're free to go back, ma'am.
Next is Ms. Taylor.
Okay, Mr. Taylor, you've been charged with 4 driving related offenses. Speeding, bond is going to be set at $500 for that. Driving on a suspended license, the bond is going to be set at $1,500. And knowingly driving on a suspended license, bond is set at
I didn't know my license was suspended.
That's something, ma'am, that at this point, these are just accusations. It doesn't mean you did or did not commit these offenses, but these are the allegations that are being leveled against you. I don't necessarily agree with that charge, but it's something that is a charge. And driving without insurance. So your bond, your total bond is going to be set at $3,500. Do you believe you can post that bond, ma'am?
Yes, ma'am. Oh, yes, sir.
Okay. You're going to have a preliminary hearing date that's going to be set for April 20th at 8:30 in the morning, but that date is going to get waived upon your bonding out. Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir, I have a private attorney, but what was the amount of total bond?
$3,500.
Okay.
Okay. Any other questions, ma'am? Okay, you're free to go back.
Thank you.
You're welcome.
Okay, the last one is gonna be Jones, the fugitive for justice.
Okay.
Good afternoon, Your Honor.
Good afternoon, ma'am. Actually, good morning for the next 10 minutes, but we're almost there.
Good morning, Your Honor.
Lord willing and the creek don't rise, as they say
Amen.
here. Ma'am, your situation is a little bit different than the others. You still have the same rights that I explained before, but we're dealing with the situation where you have not committed a crime here in Clayton County, but you are wanted out of Florida. It appears that there's a warrant for fraud out of Sarasota County, and they have indicated that they want to extradite you. I'm certain that you've probably been told a little bit about this process, but my job is to make sure that you understand the process, because you're going to have to make a decision as to whether you want to waive the right to a second hearing as it relates to this, or whether you want to have that hearing.
Investigator Bond saw me last night, and he said, sign the paper and he'll call them and give them 10 days to come get me.
So that's generally what happens. And I can't, the word that I want to use is cosign, but I can't like say that what he's telling you is the God's honest truth. But if he said that to you, I believe that's what he intends. Because what happens when you waive the hearing, the clock begins to tick and run on the jurisdiction to come get you.
That's what
And with this COVID times and stuff that's going on, a lot of people aren't traveling. And so there's a strong chance that you waive this hearing and they don't come and get you and you're going to be released. Now, that doesn't mean the warrant goes away.
Okay, sir.
So if 10 minutes from that, you're being released from the sheriff's office here, you get stopped again, you're most likely going to get arrested if they say that they will extradite. Because that's the only thing that the police officers here are concerned about. If they contact, you got a warrant, they contact the jurisdiction says they will extradite, then you're duty bound to bring you in. Okay. And the whole thing starts all over again. So if you are released, you really need to deal with whatever the issue is down there in Florida so that your life is not upturned. Because I guarantee you, when you're taken into custody, it would not be at the best time.
Yeah, and it's been hard here at the jail here, so I am going to deal with it. Okay.
So if I hear what you're saying, it's like it's your desire to waive the hearing?
Yes, sir. So they can, the time can start ticking, he said.
Okay. So the deputies there will have the paperwork and they will have you sign it and they'll send it over to me and then I'll sign it and it'll all go back today with the paperwork when I send everything back to the sheriff's department. And then the clock will start running today. Do you have any questions of me, ma'am?
No, sir.
Okay. All right. So, you're welcome. So we'll have Ms. Jones sign the waiver paperwork, and then when I receive it, I'll sign it and send it back.
Thank you, Your Honor. Have a good day.
You're welcome. Okay, we're ready to start on the men's side.
Here we go, Mr. Bailey.
Have a good day on the women's side. I'm sorry.
Yes, sir, you too.
Okay, Mr. Bailey.
How you doing, sir?
I'm doing well. You charged one count of driving a vehicle with an expired tag and one count of violating Georgia Controlled Substance Act. You're gonna have a total bond set at $5,500. Do you believe you can post that bond, sir?
Yeah. Yes, sir. Yes, sir.
Okay, so the drug charge is a felony charge, and that means you're gonna have a preliminary hearing date set for April 19th at 8:30 in the morning.
So I won't be able to get up on bond?
Yes, sir.
All right.
Yes, sir. And that date will be waived upon your bonding out,
Thank you.
and you will receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir.
I'm sorry, they said no?
No, sir.
Okay, you're gonna hire your own lawyer?
A lawyer? I ain't never had no lawyer.
Okay, so Mr. Bailey, I can't force a lawyer on you, and I'm not gonna do that. If you tell me, it sounds like you're saying you wanna represent yourself on these charges?
I'm gonna have to pay the lawyer.
You do have a lawyer?
Nah, I'm gonna have to pay the lawyer, like pay him, pay her.
Okay, so you have a lawyer,
No,
but you're gonna hire a lawyer.
no.
Okay, let me ask you this one more time.
So if you get me a lawyer, sir, would I have to pay that lawyer, sir?
No.
Oh no. Well then, can you get me a lawyer, sir?
Okay. You do qualify, Mr. Bailey, so I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
Yes, sir. That drug charge, I just had one blunt. Like I just had one blunt, literally a 0.5. That's about it. And I had. That's it.
Okay, so and that's the importance of having a lawyer, Mr. Bailey, so the lawyer can advocate on your behalf as it relates to these charges. So I've appointed a lawyer for you, and that lawyer should help you in this instance. I do see, I think it was more the felony charge is related to how it was packaged rather than the weight. And that's something a lawyer probably can deal with.
I think so.
Okay, you're free to go back. Tell me your name, sir. Okay, sir, you've been charged with 1 count of possession of marijuana less than an ounce. The bond is going to be $1,500 for that. You've also been charged with tampering with evidence. The bond is going to be set at $2,000, and an open container violation where the bond is going to be set at $500. So you're going to have a total bond of $4,000. Do you believe you can post that bond, sir? Okay. You're going to have a preliminary hearing date that's going to be set for April 20th.
April 20?
At 8:30 in the morning. Yes, that date is going to get waived upon your bonding out, and you'll get a new date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. You do qualify, sir. So I'm going to appoint a lawyer to represent you.
Okay, no problem.
Okay. Do you have any questions of me?
No, I'm gonna need somebody to let me call, because I gotta call my uncle so he can pay for my bond. So
Okay, so
I need my phone to get my number on it as well.
okay, sir. The sheriff's department, they have their own protocols, so I can't like tell them what to do as it relates to that. But if you're not able to use your phone, you can use 411 to contact any person that you're trying to contact, okay? And they will allow you to use the phone after this hearing is over, but it's not a circumstance where you're gonna just automatically go down there and get to say, I need my phone call. They have their procedures in place. Hold on. They have their procedures in place, and they will allow for that to happen, okay?
Okay.
All right. You're free to go back, sir.
Excuse me, Honor.
Yes.
Can we go out of order for 1 second and get Mr.
Sure.
Danny South?
I'm sorry, it's Mr. Who?
Danny South.
Okay, yes.
And he did not fill out one of the court-appointed forms.
Okay. Mr. South, you've been charged with 1 count of false imprisonment, 1 count of battery, and 1 count of violation of Georgia Controlled Substance Act. You're going to have a total bond set at $20,000, and there's going to be a stay away provision on the bond to stay away from Patricia Williams. Do you believe you can post this bond, sir?
I do believe so.
Okay. And do you understand the stay away provision?
Yes, sir.
Okay. Now, you didn't fill out this form as it relates to your being appointed lawyer. Is it your desire to hire your own lawyer or to represent yourself?
No, sir.
Okay. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah, I would.
Okay. Are you currently employed, Mr. South?
Right now I am. Probably the next few days I won't be.
Okay. Approximately how much do you make per hour?
$15.75.
I'm sorry?
$15.75.
Okay, Mr. South, you do qualify for the appointment of a lawyer. I'm going to appoint a lawyer to represent you. And because you didn't fill this form out before, you have to make sure that the information you give the sheriff's department as it relates to your address is, or your contact information is true and correct. So the law firm can contact you, okay? Do you have any questions for me, Mr. South? Okay, you're free to go back, sir.
You go back on down.
Are you Mr. Bellamy?
I am, sir.
Mr. Bellamy, you've been charged with 2 driving-related offenses. The total bond is going to be set at $2,000. Do you believe you can post that bond, sir?
No, I don't. I'm a disabled veteran. I take 8 different mental health medications. I'm type 2 diabetic with insulin. Also metformin and glipizide. I can't make that bond on. I asked the court for a bond reduction so that I can get to my mental health medication, sir.
So, Mr. Bellamy, these the bonds for these offenses are set by what they call a schedule, which means that the judges have met and they've made determinations as to certain offenses and the bonds that they believe to be reasonable as it relates to that. So I'm not going to be able to reduce this. However, there is a veterans treatment court that is getting started up in Clayton County. And it's being run by Judge Mack, and I will send your information over today to Judge Mack so that you can be placed in their treatment court. And it's something that basically it's sort of a program that instead of you're being found guilty or not guilty of these offenses, it will be something that, hey, we're going to work with him. So he's driving on a suspended license. All right, so we're going to help him get his license straightened out. Everything straightened out. Not going to deal with the criminal consequences of this. So I'm going to do that. And you're going to have a preliminary hearing date set for April 20th at 8:30 in the morning. You do qualify for the appointment of a lawyer, so I'm appointing a lawyer to represent you. So that's what we're going to try to do for you, Mr. Bellamy, to get this situation straightened out. Do you have any questions of me, sir?
But 2,500 still is in place.
Yes. What I would
And some have it to the screen, officer. Some have it to the screen.
Yeah, he's close.
Excuse me, are you frozen?
Okay, I apologize. I received an email from Mr. West, and I was trying to print it out. And apparently, it was a big power drain. So, Mr. Bellamy,
Yes, sir.
you're going to have a lawyer appointed to represent you. I'm going to refer you over to the Veterans Treatment Court as it relates to the bond amount. There are a number of bonding companies that are authorized to write bonds here in Clayton County, and they will work with you. And some of them will even put you on payment plans. So
Yes, sir.
you'll be able to get out, but you're gonna have to do the work and do the effort to go through that. So do you have any other questions for me, Mr. Bellamy?
No, sir.
Okay, you're free to go back. Good afternoon, Clark.
You're going in and out, Your Honor.
Okay, I'm sorry. Who is this before me?
Michael Dunbar.
Mr. Dunbar, Your Honor.
Okay. Mr. Dunbar, you're charged with one count of terroristic threats or acts. The bond for that is going to be set at $10,000. Do you believe you can pay that bond?
Yes, sir, I believe so, Your Honor.
Okay. There's going to be a stay away provision on the bond to stay away from a Shelby Kinney. Do you understand that?
I understand you.
Okay. This is a felony offense. So you're going to have a preliminary hearing date that's going to be set for April 19th at 8:30 in the morning. But that date is going to be waived upon your bonding out. Would you like for me to see if you qualify for the appointment of a lawyer?
No, thank you, Your Honor.
It says Christopher Brown and Clint. Are those, you have a lawyer already?
Yes, sir.
Okay. Well, make sure you tell your lawyers of that date. But again, that date will be waived upon your bonding out. Do you have any questions of me?
No, sir, thank you for everything.
Okay, you're free to go back.
All right, thank you, sir.
You're welcome.
You have Mr. Clark.
Okay.
How you doing, sir?
I'm doing well. Mr. Clark, it appears that you've been charged with one count of family violence battery, one count of criminal damage to property in the second degree. You're going to have a total bond set at $7,500. But you're going to also have a stay away provision on this bond to stay away from a Micaiah Smith.
Makash.
Okay.
Yes.
So do you understand that, sir? You understand the stay away provision?
I do, sir, but can I be totally honest with you?
Yes, sir.
We both have a support system with each other. It was just she found a girl in my phone. She stayed with me. We've been staying together. We were homeless. I'm the sole provider. But if need be, I can let her stay with my brother. She's not in fear for her life, and she will contact the DA. She came to pick my car up. She got my car now, and she stays with me. She has my car now. I'm the sole provider, and I work. I try to do the best I can. So it was just something that I missed out. I mean, I didn't do what she said I did. And, she kind of bipolar, but I still love her. So I've just been totally honest with you.
No, I understand. So make sure that she makes those arrangements or those contacts before you go back around her, or you could be in a situation of getting felony charges. Well, I mean, the criminal damage to property in the second degree is a felony charge, but you could get additional felony charges and your bond could be revoked.
Okay, that's fine.
Would you like for me to see if you qualify for the appointment of a lawyer?
Sure.
Okay, you do qualify, Mr. Clark. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
I have one more question. I work and I'm paycheck to paycheck. I was wondering, could I get a little bond reduction so I can make bond possible?
Well, the way that the bond reduction, well, not even bond reduction, but there's a schedule that we have, and I've set the bond the lowest amount for the battery charge.
Okay.
So it's going to be something that you're going to have to work with the bonding company.
Okay, that's fine.
Okay.
Yeah.
All right. Anything else, Mr. Clark?
Thank you. Have a great day.
You too.
All right, thank you.
Hello, Your Honor.
Hi, tell me your name, sir.
Anthony Goodrich.
Okay. Mr. Goodridge, you've been charged with 2 drug-related offenses, actually 3, with the use of possession of drug-related objects, 2 felony offenses, and 2 misdemeanor offenses. The window tint bond is going to be set at $500. The use or possession of drug-related objects bond is going to be set at $1,500. And then for the 2 drug-related offenses, felony offenses, bond is going to be set at $10,000 a piece. So you're going to have a total bond of $22,000. Do you believe you can post that bond, sir?
Yes, sir.
Okay. You're going to have a preliminary hearing date that's going to be set for April 19th at 8:30 in the morning. That date is going to get waived upon your bonding out. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. You do qualify, Mr. Goodrich. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Thank you. Good morning, Your Honor.
Good morning. We've actually passed the threshold. It's the afternoon now. Tell me your name, sir.
Jared Mason.
Okay. Mr. Mason, you've been charged with 1 count of aggravated battery and 1 count of cruelty to children in the 2nd degree. I cannot set a bond at this stage on these offenses. It looks like you said your lawyer is Leon Hicks. Okay. So tell Mr. Hicks that you have a preliminary hearing date that's going to be set for April 21st. And you're going to have a bond hearing date set for April 23rd. Now, Mr. Hicks can contact the DA's office and can possibly work out a consent bond with them on these charges. But this is a situation where I can't set a bond. I am going to also put a stay away provision on your bond to stay away from a Sarah Alexis Jones. And what that means is that you're not going to be allowed to contact Miss Jones while you are in custody. And you're not going to be allowed to contact her if you get a bond and you're on the street unless this provision has been lifted. Do you understand that, Mr. Mason?
Yes, sir.
Okay, do you have any questions of me, sir?
Yes, sir, I do have the question.
Okay.
So, my question is I had 2 police reports filled out only one Wednesday and one Friday, but the police officers that came to the car on Wednesday, they said they wasn't able to process the warrant because it was in the wrong jurisdiction. And 2 days later on that Friday, I guess she went to go get another one. And I'm confused. I'm still baffled on that.
Do you know the first police officer where they were from?
Sir?
Do you know what jurisdiction the first police officers represented? The one that said that it was in the wrong jurisdiction?
That I have, I don't have the police officer's name, but my dad and the lawyers do.
Okay. So, generally what happens is that the place where a crime is alleged to have occurred, that's the proper jurisdiction. So you have people sometimes, they live in Fulton County or they live in Clayton County, and something happened in Fulton County, but they try to come to Clayton County and try to get a warrant. Well, whatever happened in Fulton County, that's the appropriate jurisdiction for it to be dealt with. So that may be what's going on in your situation, but it can be, as I say, cured, which is mean fixed by just going to the appropriate place. So criminal felony charges, generally, there's a statute of limitations of 4 years. So if something happened today, the state of Georgia has 4 years to try me on it. And they can try like 15 times. There's nothing that stops them from getting it right. Okay? All right, you're free to go back, Mr. Mason.
Mitch McConnell.
Okay. Mr. McConnell, you've been charged with 5 offenses. Reckless driving, I'm going to set the bond at $2,000 for that. Possession of marijuana less than an ounce, the bond is automatically set at $1,500. Use or possession of drug-related objects, the bond is set at $1,500. Theft by receiving stolen property, bond is going to be set at $10,000. And possession of a weapon during the commission of a crime, bond's going to be set at $5,000. So you're going to have a total bond of $20,000. Do you believe you can post that bond, sir?
Yes, sir. But can I get a bond reduction?
I'm not going to reduce the bond on this, Mr. McConnell.
That's cool.
Would you like for me to see if you qualify for the appointment of a lawyer?
Sure.
Okay. It looks like you do qualify, Mr. McConnell. I'm going to appoint a lawyer to represent you. You're going to have a preliminary hearing date that's going to be set for April 19th at 8:30 in the morning. That date is going to get waived upon your bonding out. Do you have any questions of me, sir?
No, sir. You said I got a $20,000 bond, right?
Yes, sir.
That's it. That's all I want to know.
Okay, you're free to go back.
Appreciate you.
How are you doing, sir?
I'm doing well. Tell me your name, sir.
Joshua Miller.
Mr. Miller, you're charged with 1 count of public drunkenness and 1 count of obstructing an officer. I'm going to set your total bond at $3,000. Do you believe you can post that bond, sir?
Yes, sir.
I'm going to set a preliminary hearing date for April 20th at 8:30 in the morning, but the date to get waived will be waived upon your bonding out, and you will receive a new date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
I got a lawyer, sir.
Okay. Who's your lawyer?
It's the same lawyer I've been having since I was 15 years old.
That's a long string, but I don't know the lawyer's name. Who's the lawyer?
Dan Edwards.
I'm sorry?
Dan Edwards.
Okay. And I just asked that because I write it on the form so that you're not in a situation where somebody's going to try to contact you. But if you don't have any questions of me, Mr. Miller, you're free to go back.
All right.
Good afternoon, sir.
Good afternoon. Tell me your name, sir.
Xavier Reed.
Mr. Reed, you've been charged with, it looks like 6 offenses. No tail lights and improper lane change. The bond is going to be set at $500 for each of those offenses. Driving on a suspended license, the bond is going to be set at $1,500. violation of Georgia Controlled Substance Act. The bond is going to be set at $5,000. Possession of a weapon during the commission of a crime and possession of a firearm during the commission of by a convicted felon. It looks like what that charge is. The bond for each of those is going to be set at $10,000. So you're going to have a total bond set of $27,500. Do you believe you can post that bond, sir?
I do.
Okay. You're going to have a preliminary hearing date set for April 21st at 8:30 in the morning. That date is going to get waived. I'm sorry, April 23rd. Sorry. At 8:30 in the morning. That date is going to get waived. Oh, I'm sorry, Mr. Reed. I'm looking at two different numbers. It is going to be April 21st. Okay. And that date will be waived upon your bonding out. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, Mr. Reed. I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
You said 27,000?
Yes, sir.
Okay. That's it.
You're free to go back.
Appreciate it.
Have your name, sir?
Hey, good afternoon. It's Mr. Scott, Clayton Scott.
Okay. Good afternoon, Mr. Scott. You're charged with one count of simple assault. I've set bond at $3,000, but I've also put a stay away provision on this bond.
Okay.
It looks like the victim's name is Marquise Scott?
Yeah.
Okay. So you're gonna have to, you're gonna have to stay away from Mr. Scott. This stay away provision can be lifted, but it's something that we said at this point. So if it needs to get lifted, you're gonna have to contact the solicitor's office to have it lifted. You're gonna have a preliminary hearing date set for April 20th, but that date is gonna get waived upon your bonding out. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, sir, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Well, I will be able to make my bond, and how soon can I make a call?
It'll probably be 3 or 4 hours from now. It generally takes me about 2 hours to complete the paperwork after the hearing, and then I send it over to the sheriff's department, and that's when they get started working on it. So they can't get started working on it until I send it to them. So it's going to take a couple hours, maybe 3 or 4 hours for it to get done.
All right, and with the bonding company, they don't close early, do they?
No, most of them stay open 24 hours, and you will know the amount of the bond, and you can tell that to the bonding company. And once the sheriff's department gets the paperwork from me, and then they enter it in, then that's when the bonding company can jump into action.
All right, appreciate it, sir.
Okay, you're free to go back.
Have a good.
You too.
I'll tell you this, Ricky.
Okay, sir, you've been charged with one count of a brake light violation and one count of, it looks like it says, driving a vehicle with no license. Your total bond is going to be set at $1,500. Do you believe you can post that bond, sir?
Yes, sir.
Okay. You're gonna have a preliminary hearing date set for April 20th. That date is gonna get waived upon your bonding out. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
How you doing, sir?
I'm doing well. Are you Mr. Smith?
Yes, sir. Yes, sir.
Mr. Smith, you've been charged with 1 count of driving on a suspended license. The bond is going to be set at $1,500 for that. You believe you can post that bond, sir?
Yes, sir, I can.
Okay, you're going to have a preliminary hearing date set for April 20th, but that date is going to get waived upon your bonding out. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Smith. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Sir, no, sir. Thank you very much.
You're welcome. Have a good day.
You too, sir.
You, Mr. Stubbs?
I'm Mr. Thompson.
Mr. Thompson, I'm sorry.
Christopher Thompson.
Got my paperwork a little bit out of order. Sir, you've been charged with 5 offenses. Driving a vehicle without a tag. The bond is going to be set at $500 for that offense. Driving a vehicle with no insurance, the bond is set at $1,000 for that. Possession of marijuana less than an ounce, the bond is going to be set at $1,500. Violation of Georgia Controlled Substance Act, the bond is going to be set at $5,000. And use or possession of drug-related objects, the bond is going to be set at $1,500. So you're going to have a total bond of $9,500. Do you believe you can post that bond, Mr. Thompson?
Yeah. I got a question though.
Yes, sir.
What would constitute for me to get a reduced bond?
Well, for 3 of these offenses, the bonds are set by schedule, which means that the judges have met and they've decided that that's the appropriate bond for that offense. So I can't reduce that. The violation of Georgia Controlled Substance Act, that's a felony offense. And I set the bond at $5,000, which is really kind of the lowest I can set for that felony offense.
Yeah, I got a question about that offense because they charged me with being in possession of THC oil, but it was no way for them to know that I had THC oil because the pen that they observed was broken. So it was really just the inference from the police officer.
And at this stage, these charges are mere allegations. So that's where at this stage, we either appoint a lawyer to represent you or you hire your own lawyer because that's the person that's going to lead to these charges being dismissed or not.
Okay, and I got another question about the driver with expired tags and registrations. I presented the documents while I was there before they arrested me, but they was already in the process of searching my vehicle and they added the charge anyways, even though I had the paperwork to prove that the car was registered.
And that's something that I understand what you're saying, and I do see that. It will lead to the charge being dismissed later, but it doesn't help you now because I have to set a bond on each charge. So I understand what you're saying.
Well, how much you said it was again?
You gonna make me do math again, Mr. Thompson?
Man, something.
Okay, all right, hold on, sir. $9,500.
All right.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, Mr. Thompson. I'm going to appoint a lawyer to represent you. Did I tell you the preliminary hearing date of April 21st? That date will be waived upon your bonding out. Do you have any other questions for me, Mr. Thompson?
No, sir.
Okay, you have a good day, sir.
Thanks, you too. Good afternoon, sir.
Good afternoon. You're Mr. Thomas?
Yes, sir.
Mr. Thomas, you've been charged with 5 offenses, 2 drug-related offenses, and the bond is going to be set at $5,000 a piece for those. Driving on expired tag, the bond is going to be set at $500. No insurance charge, the bond is going to be set at $1,000. And license not on person, the bond is going to be set at $500. So you're going to have a total bond of $12,000. Do you believe you can post that bond, sir?
Yes, sir.
Okay. You're going to have a preliminary hearing date that's going to be set for April 21st. That date is going to get waived upon your bonding out. It's going to be 8:30 in the morning, and it'll be a Zoom hearing, like we're having here today. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir. I have just one small question.
I'm sorry.
I have just one question.
Okay, you do qualify, Mr. Thomas. I'm going to appoint a lawyer to represent you. What's your question, sir?
Is there a way I can get like a small reduction or anything like that?
So the 2 biggest bond charges are the violation of Georgia Controlled Substance Act.
Yes, sir.
And I've set those at $5,000 a piece, and that's really the lowest that I can set those felony drug offenses for. So I don't see the other bonds are set by schedule by the judges. So I don't see a room to reduce this bond.
That's understandable, sir. You said 12,000, sir?
Yes, sir.
All right, thank you. Have a good day.
You too.
All right. That's everyone, Your Honor.
Okay, let me just verify. So on my side, what I have is I'll try to go in order. Mr. Cox's OTB. Robert Cox.
Yes, he's OTB.
Okay. Let's see. Claude Joseph is OTB.
Yes.
Okay. And Dante Stubbs is OTB.
Dante Stubbs. Yes.
Okay. And Leon Walton.
Yes.
And the last one I have is John Wyatt Jr.
Yes.
Okay. All right. Thank you, gentlemen. You have a good day.
You too, Your Honor.
We'll do it again tomorrow.
Yes, sir.
Okay. Goodbye.